Hi, it's Diana Iacosavas, and I'm sitting here with the head of class actions for Diamond and Diamond, Mr. Darryl Singer.
Hello.
And of course, the managing partner of Diamond and Diamond, Miss Sandra Ziskind.
How are you?
I'm good. How are you guys?
Great.
Good. I think on our last episode, we talked about class actions.
Correct.
Which I think I get now. Yeah, I'm good. I got it. Yeah, I got it. It's all registered. But now there was another something that was throwing me for a loop, which is something called mass torts.
Correct.
Come on. What is there?
We're just making up legal things to
Like,
mess you up so that when you go to work, we're just going to keep making up words. We're just keeping making up words. That's exactly what it is. But I'm going to let Darryl explain the mass tort for you. Go ahead, Darryl.
A mass tort? And then I'll lead to my next question.
All right. In simple terms, a mass tort is sort of, not to make it too complicated, but sort of like a class action, but it's not. So if you remember in our last episode, we talked about a class action, which is one claim with dozens or hundreds or thousands of people suing.
Okay.
In a mass tort, you have those dozens or hundreds or thousands of people, each starting their own individual case against a particular defendant for a particular thing. And then we join all of those individual cases together, but everybody is still their own case.
Okay, so just back up for a second. So
All right.
you're going to sue, okay, so
you're suing the same defendant.
Okay, you're suing
so essentially you have the same defendant.
Okay.
But what happens is in a class action, the class has to be so alike that it makes it sort of dumb to do it any other way because everything is so similar. So on the really easy cases like a data breach, everybody's data is breached the same way. So it's really easy on a class of thousands and thousands. You're not going to do thousands of individual lawsuits because it doesn't play for each person individually. Everybody's data was breached the same way. It makes sense to do it as a class action, same defendant, easy. But now you take a case, for example, like we're doing mass torts with Roundup, okay? Roundup is...
Is that little thing that you spray on your...
Yeah.
Correct. Yeah. And it caused cancer in a lot of people. So what we're suggesting is that a mass tort makes more sense in a case like that because people got sick in different ways. So in a mass tort, each plaintiff gets to put forth their case in their own unique way.
Wow.
So in the Roundup case, for example, everybody may have used Roundup in a different way. Some maybe were farmers. Some were just regular gardeners at home.
Parents used them.
Right. Some people used it for 20, 30, 40, 50 years. Some people got sick after using it for 2 years. Some people got very, very sick and have very serious forms of cancer where they sadly may pass away before the lawsuits ever get to trial. Other people have a relatively minor level of illness. So in a case like that, it makes sense to do each case individually. And also, we think in a case like that, the individual resolution, whether by settlement or judgment for each person, will be more than if they were part of the class. So there is also a Roundup class action that we're not doing. And we've got several hundred individual cases that we're running.
So you're going after this massive corporation Roundup for each single person. So you're correct. You're filing things separately. You're collecting different
hundreds of separate claims. Correct.
Because everybody has different levels of.
Correct. But
there's no, like in the class actions, are there different, I don't know, you call them classes or you call them
no, because
torties?
Everybody has their own claim.
Torties?
No, everybody has their own claim. But what often happens is in these mass torts is because the defendant is the same.
Yeah.
What the corporation might decide to do is say, look, give me, we're not going to examine all the plaintiffs because what they do is go to a discovery where they answer questions. So they may not want to examine 500 plaintiffs because that will take forever.
Right.
But what they'll say is, okay, everybody who's had really bad cancer and passed away, give me one person from that group, give me one person from that group, give me one person from each individual group, and then we can examine them and settle out each claim based on a sort of subgrouping within the group.
Or you run a trial and it's called a test case.
Correct.
So you might have, if there's 300 individual cases, you might have 4 to 6 or 8 test cases. And then based on what happens in each of those cases, everything else will just ultimately get resolved based on that.
It's very similar to a class. The only difference is that the damages for the plaintiff are so unique to the plaintiff. It would, in our opinion, it would be doing them a disservice to do it as a class. Because in a class, you are one of 1,000, like we've said before. So for example, when we did Tim Hortons, and I can talk about that publicly because it was a public document.
case, yep.
Tim Hortons was easy because
Went after Timmy's?
we went after Timmy's. I'm sorry. That just
Canada's,
I know. It's settled. We're friends again with Timmy's. It's okay. Everything's okay. I just want to let you know we've made peace with them. It's all good. If it's settled, it's all good.
Great Timbits.
Yes.
Side note, go ahead.
So in that case, it was easy because it was a data breach case,
Yep.
and everybody was affected the same way.
Okay.
So there was no individual, but in Roundup in particular, like Darryl said, some people are deathly ill.
Mm-hmm.
Some people are not, are minorly ill. So it doesn't make sense. It's not fair that everyone gets the same settlement.
Okay.
As they did, for example, in the Tim Hortons one.
The other thing to point out is in a case like Roundup, you have people that are at very advanced stages of illness, and we can move a mass tort much faster than you can move a class action. Class actions have additional, we won't get into the weeds on it, but there are additional...
The weeds. Yes. No pun intended.
But
Going to get in the weeds with Roundup.
Yes, that's right.
But there are additional steps required in a class action that stretch out a class action perhaps 1 to 3 years longer or more, as opposed to a mass tort, which we can move much more quickly because it's kind of the same as just moving one individual case for one person.
Got it.
And so we can move much more nimbly and get to trial faster.
Is it the same thing that what we discussed with the class? Like, is anybody automatically entered into a mass tort?
No.
In a mass tort, you must individually retain us.
Okay.
And we must issue a claim in your name.
So there's no rep plain. You are the plaintiff.
Correct.
Your name is out there.
But
There's
if we're doing a mass tort and another firm is doing a class action and you don't sign up with us to do a mass tort, to do an individual claim as part of our mass tort, you'll automatically be part of the class action that's out there.
Because everybody that falls into the category is automatically part of the class action, you have to actively opt out. So for example, a lot of our Roundup clients came to us and said, listen, we don't want to be part of the class action. Our claim is special. It's unique.
Right.
We want to sue on our own. They opted out of the class action.
They will.
Yes, they will opt out of the class action.
And again, for the mass torts, if somebody comes to you and says, I was affected by Roundup or this or whatever, Tim Horton or whatever the case may be, are we charging these people?
No, entirely on a contingency basis. If we don't get them any money, they don't pay.
Contingency through and through.
Through and through.
Amazing.
We take all the risk as a firm.
And so, okay. And even with the mass torts, does it backdate to the night, let's say, you were saying 20, 30 years people are using this product?
It's individual.
It's individual, so it depends if it's an ongoing tort. So if they continue to have exposure to it, essentially the limitation period's 2 years. But if the 2 years has been ongoing, so for example, you started using Roundup since 2000 and you're still using it till now, we can still issue a claim for you if you've gotten sick from it.
In the last 2 years.
Correct.
It may very well be that they used Roundup for 30 or 40 years, and they didn't know that Roundup was the problem until they got sick.
Correct.
Right? And so then they're within...
It's when you knew or ought to have known you had the 2 years runs from when you knew or reasonably ought to have known you had the action. So if you didn't know that you got cancer from using it 30 years ago and you just found out yesterday, the timeline would technically go from yesterday.
And so what happens in a lot of these cases is that people will have some sort of illness and they don't actually know until there's some media coverage about it.
Right.
Either there's a recall of a product,
right,
or there's a class action that gets lots of press coverage, and then the people say, oh, well, that's what connects it. Now I connect the dots. And at that point, they come to us and say, I don't want to be in the class action. I want to sue on my own.
Okay. So we get the one call from the one person, let's say with the mass torts. So somebody calls in and says, hey, I had this issue. I just found out this Roundup. There was a recall, Is there anything you guys can do to help me? And at that point, you're like, okay, let's sit back and wait to see if more people are going to call us, then we'll go class action. Or you're just like, no, these injuries, these damages are way too significant to move forward, and we're going to do a mass tort for you.
Well, it wouldn't be a mass tort for that person. Usually what happens is we end up in these mass tort situations because we're not just receiving one call. Like typically, if we talk about a drug that was recalled, for example, there's lots of media coverage, right?
Right.
That Health Canada is recalling a drug, and there's all kinds of news coverage about lawsuits being started in the States. And so we're not getting one call in that particular period where there's all that media coverage around a recall. We've had weeks where we've literally had 100 calls for the same thing. And so that's when, Sandra and I will sit down and say, okay, we've got a number of people.
Yeah.
Let's do these as
But this
individual
person has
claims.
this severe issue,
Right.
lost their family member or
Right.
whatever, and then this person's in the hospital right now, and you're like,
Yeah.
this makes more sense to go this route.
Right. So you're
What a bunch of brains we're sitting between
You're
over
sitting
here.
between the brains that decide if we're going class action or mass tort route, basically. Daryl and I sit in a room and we
Flip a coin.
And we go. We don't flip a
They
coin.
don't
It's a little.
actually
It's a little bit
scrap that
better
from
than
the
that.
record. There's
It's
no
a little bit.
flipping of any
It's a little bit better than that. But we go back and forth of the pros and cons, and we always think about what's the best interest of the client.
That's,
the goal. You always have to be thinking about the best interests of the client.
of course, that's what we do here at Diamond and Diamond.
Correct.
Okay, so I think I got it. I think I understand the difference between a mass tort and a class action. If somebody were to call us in with the next big, I guess, thing that we were willing to take on,
Yes.
then at that point you guys would flip a coin and then decide how we would proceed.
Correct.
Well, here's to hoping, more people don't get, there's no injuries further or anything like that, and we can proceed as is, but unfortunately that's how the world works, everyone.
That's why we need Diamond and Diamond.
That's why you need Diamond and Diamond, because we do it all. Daryl, Sandra, always a pleasure. Thank you for making me smarter and
Thank you,
happier and informing me about everything. Cheers.